Okay, good evening, everyone. Okay. Very good evening, Kanika. Please confirm about the voice and I'll start this session. Yes, Kanika, please confirm about the voice and the video and I'll start the session. Okay, thank you, Kanika, for confirming that. On that note, let's begin with this class. Okay, so first of all, I welcome each one of you to my YouTube session on Muslim law. So let's start with my brief introduction. My name is Sandeep Khatri. I have done my law from University of Mumbai and my LLM from Judicial Global Law School. My areas of specializations are the constitutional law, criminal law, commercial law, family law, and law of torts. Here is the link of my profile on Unacademy. So please do follow that to get all the updates about my special classes and about my plus courses. I've also shared the link for my Telegram channel where you can connect with me. Sorry. And at last, I have mentioned my code, that is KHATRILIVE, which you can use to get free access of all the special classes available on Unacademy app and also to get 10% discount for the plus courses. Now I request everyone, please be attentive, and this is going to be an interactive session. So what I'm going to take today is all your questions, problems related to Muslim law, anything which you are not clear with. And I'm also going to cover one of the important section number, that is section number 2 of the Dissolution of Muslim Marriage Act 1939. So Kanika, if you want to ask anything, please. Yes. Anything related to Muslim law which is not clear to you from the topics which we have already covered. Any form of talaq which is not clear to you. Okay, so I'll start with this one. In that case, we will start with the Dissolution of Muslim Marriage Act 1939, section number 2. I'll conclude this concept. So when it comes to section number 2, this tells us the grounds for divorce. And now what are the grounds of divorce? So first thing, before entering into the grounds of divorce, let's do the introduction part. Kanika, in exam you may expect all kind of questions. They may ask you like what are the kinds of talaq. They might ask you what are the kinds of talaq, what are the different forms of talaq which are available. So all of these questions have the same answer, that is what are the kinds of talaq which are available in Muslim law for the husband, for the wife, for the mutual consent, and by the court. Okay, now coming to this one, students, when it comes to section number 2, what are the grounds of divorce? So the first thing I want to tell you, all these grounds are available to wife only. When it comes to section number 2, whatever grounds we are going to talk about, all these grounds are basically that is related to wife only. That is related to wife only. Now, first question is why not husband? First question is why not husband has been included. The reason is very simple, students. When you will go into the history of Muslim law, and when we go into the concept of divorce, so divorce is since the inception of the concept of Muslim law. Okay, and all the forms that are available, all the forms are exclusively for husband only, and this is the reason that when it comes to section 2, all the grounds are available to wife. When we say talaq-e-tafweez, that is a kind of divorce, that is a kind of divorce which is that is a kind of divorce which are, the wife, which is available to wife, but still that is called as delegated divorce, which means if the husband is giving the power, if the husband is giving the power to the wife, then only wife can, use talaq-e-tafweez, which means technically there is no such concept for talaq which is available for wife if she wants to give to the husband. And there comes the role of section number 2. So this was basically the overall introduction of the grounds of divorce. Now we are entering into the details. Now we are entering into the details. Just give me a second. Now when you are entering into the details of this concept, it says that under section number 2, the first ground which is available for wife is if the wife does not know about the whereabouts, एक बार देख लेना कितनी कॉल्स की हैं. If the wife does not know about the whereabouts of the husband, which means if the wife has no idea where the husband is for 4 years, which means the husband may be died or husband may be alive. If the wife has no idea, then the wife gets the ground to take the divorce from the husband. Now in this scenario, if the wife will move to the court and the court came up with a judgment, now this judgment is going to be effective only after 6 months. If after those 6 months, within that 6 months also, if there is no knowledge about the husband, then this is going to be effective as divorce. I hope we are done with the first one. Kanika, just give me a confirmation so that I can move to the next one. Okay, perfect. So let's move to the next one. The next ground is the second one. Now I'm going to give you some keywords so that you can remember this. If the husband neglected the wife, that is for 2 years. Okay. If the husband neglected or does not provide maintenance, neglected in what sense? Maintenance. For 2 years. See, when the marriage is going on, as per to the Muslim law as well, the wife has all the rights to take maintenance from the husband. And if the husband is not giving the maintenance for the continuous period of 2 years, for example, it was 4 years in the first case, in the second case it is 2 years. So the wife is again got the ground for divorce. Now coming to the third one. The third one is related to if the husband got imprisonment. Imprisonment for 7 years or upwards in any offense. When the husband got imprisonment for 7 years or upwards, in that circumstances the wife may go for the divorce. The only condition attached to this clause 3 is that this decision must be final, which means now the husband left with no other option of appeal. That should be the final order. Next one, fourth one is when husband failed to perform marital obligation. Marital obligations here means if there is a husband, there is a wife, then wife has some rights over the husband and husband has some rights over the wife. And if the husband is not performing his marital obligations, then in that scenario, the wife get the ground for divorce. The next one, fifth one. Kanika, you are asking about sir third में कुछ भी, third point is this one, imprisonment में कुछ भी ये नहीं है कि particular offense के लिए अगर punishment हुई है तो no, we are not concerned for what offense the husband has done. No, we are concerned with what punishment. If the husband is going into a jail for 3 years or even any time of period which is less than 7 years, then the wife will not get a ground. But if that time period is 7 years or upwards, in any of the offenses, that would be a ground for wife to take the divorce. Okay. Now the next one, fifth, that the husband has been in, fourth one first. So we are first, second, third, fourth. We are done with the first 4. And the fifth one is impotency. One of the major objective of nikah is the procreation of children. And if that is the case of procreation of children, and if the husband is important, then wife got the ground that she can go for divorce. But again, there is one more condition attached to this one. There is a proviso, or you can, yes, there is basically a proviso for the fifth condition, and that is the court will give 1 year to the husband. And if the husband has the kind of, when it comes to impotency, that there is also kinds of impotency. So if the husband can overcome from that, okay, within 1 year, the wife will not get the right. But if the husband, but if that is the case, that the husband went to the doctor as well, he could do whatever he can, but still, the results is the same, then the wife got the ground for divorce. That is the first 5 grounds where wife can take divorce. Any questions, Kanika, till now? After that, I'll move to the next one. Yes, students, any questions till now from the first page? Because now I will just move to the next slide. Okay, perfect. Thank you for the confirmation. Now moving to the next one. The next one is the 6th ground, which is basically when the husband is dealing with any venerable disease. I'm writing in the short. When the husband has been insane for a period of 2 years or suffering from leprosy or virulent venerable disease. So there are 3 grounds. Leprosy or insane. Insane for 2 years. And if the husband has any kind of this kind of a disease or leprosy, which means basically the short point here is in the 6th ground is if the husband is suffering from any kind of disease, then the wife has all the grounds to take the divorce. 7th is the option of puberty. At the time of nikah as well, I have told you about this concept that if a girl got married at the age of suppose 13 years with the consent of guardian, when this girl age is of 15 years until 18 years, from 15 till 18 years, this is the window where this girl, the wife, can choose option of puberty, which means she can go for divorce within this period. So if she having been in marriage by her father or any other guardian, obviously because if she is getting married at the age of 13, that is only possible with the consent of the guardian. And before she attained the age of 15 years, reputed the marriage before attaining the age of 18 years. So after 15 and before 18, she has this option where if the marriage has not been consummated during that time, then she has option of puberty, which means she can get the divorce. And now coming to the last ground. Last ground is one where the husband is doing any kind of cruelty. Now, what is cruelty? You know, this concept has a history. Okay, Saurabh Fogart, you are saying, sir, reciprocity is no more. Okay, maybe I am using the previous act. Yes, it is not part of Hindu law, that for I am sure. But for Muslim law, I need to confirm that. Okay, so maybe in the next class, I'll confirm that. Done, Saurabh? Okay. Now I want to explain this concept of cruelty. And this concept has a history, students. History in the sense, when we say cruelty, the first thing that comes in our mind is the physical beating. Obviously, the first concept that comes in our mind is physical beating. Okay? But now, as of now, this cruelty means physical and mental. Let's take one example. If the husband break the hand of the wife, that is something which is physical cruelty, and mental cruelty is something if the husband is not touching the body of the wife, but he's passing such statements like, I want dowry, or I want this, or I want that from your family on a daily basis, that will obviously amount the mental cruelty. Now, some of the examples of what can be the physical and what can be the mental cruelty, let's discuss one by one. The first one is that the husband treats her with cruelty, that is to say, habitually assaults. So assaulting habitually on a daily basis, that I am going to kill you, I am going to beat you. So these kind of assaults also comes under the concept of cruelty, and the wife has all the grounds to take divorce from that person. Second one is associates with women of evil repute, which means extramarital affair. If the husband is having any kind of extramarital affair, then the wife got the right of divorce. Next, attempts to force her to lead an immoral life, which means if the husband is pushing her to live a kind of a immoral life. So what is immorality? That is very, very subjective as well. But in general, let's take an example. If the husband is pushing his wife into prostitution, so that is a valid ground here. Next one, disposes of her property. Now we all know that woman can own property. Woman can be the absolute owner of her property. Now suppose wife do have some property on her name, but the husband is not allowing her to to have the possession or to enjoyment of that property, or misusing that property for himself only, so that can again be a ground for divorce. Next one is your obstructs her in observance of her religious profession. So suppose she wants to embrace the religion of Islam, but the husband is wants to convert her, or husband don't allow her to read the namaz or any kind of religious activities, which is completely allowed in Muslim law. So she has all the rights to take the divorce. Next one is if he has more than one wife. We all know that when it comes to Muslim law, one person may have maximum 4 wives at same point of time, but there is one condition as well. If there are more than one wife, suppose if there are 2 wives or 3 or maximum 4, in that case the husband needs to treat everyone equally. In any case, if suppose if a 2 BHK of flat has been given to wife number 1, then all the 3 wives also have to be given the 2 BHK of flats. So this is basically kind of equality in the sense, equality in the treatment. Okay, so if the one wife is feeling that everyone is getting whatever they wants to, but I am the one who is not getting anything, so she has all the rights to take the divorce. Last 9 on any ground. sorry, on any ground, which is basically kind of your miscellaneous one, which means on any ground where the wife, where Muslim law allows that, yes, as per to these grounds, these all have reasonable grounds where wife can take the divorce, that can also take the divorce. That is the last one, is your ninth one. So that's it. Now, anything which you are not clear with. Yes, please. Yes, students, anything you want to ask, any question, problem? Are we done with the talaq? Any question from the talaq part? Talaq part? Any form which is not clear to you? Okay. So if that is the case, if there are no questions, then I need to conclude the class. Anything else which you want to ask? Okay, then let me ask a question before ending this class. Okay, Kanika, just be quick. Be quick. After that, I will ask one question and we will conclude this class. Waiting for your question, Kanika. Okay, Kanika, I got your question. You are asking about, under Muslim law, a Muslim woman enjoys equal to 0% of rights. Okay. In that case, you can mention, yes, when it comes to the history of talaq, technically there was no ground which is available for wife. If husband wants to end the marriage, he has all the options. Like, I'm talking about the history, starting from talaq ul sunnat, he has the rights, and in talaq ul sunnat he has all the two options, talaq e hasan and talaq e ahsan. दोनों options available है. After that, talaq ul biddat, which is now unconstitutional, but in history, yes, that was the case. Okay, now the third one comes to your ila and zihar. Ila and zihar, in the history they were available, but as of now they are not practiced in India. Ila and zihar both, and also in the Middle East also there is, very few cases which has been seen where that has been practiced, but usually that is something which is not practiced anymore. But when it comes to wife, there is only one option, that is talaq-e-tahweez, which we call delegated divorce. So technically that is something which is not available to wife. So yes, you can do write all the points. But now if we talk about today, yes, we do have section number 2 where she can take the divorce, and we have just discussed all the grounds. So there are enough number of grounds where she can prove that if she is going through with any of one of them, she can take the divorce. Yes, ये सब exceptions ही हैं. These all are exceptions only. These all are exceptions only. Done? Okay, now I have one question for you. If you are not asking anything, then just answer this one. The question is, students, that there is one form of talaq which is known as lien, which is also known as false charge of adultery. This is also known as false charge of adultery. Now what exactly this concept is, if suppose this is the husband and he made a statement. Basically he put a charge, false charge. He made a false charge on his wife that she is in the adultery. In this situation, the wife has got all the rights to file a suit and take divorce. This is basically the concept is. Okay. Now my question to all of you is, when it comes to the concept of lien, can this statement which has been passed by the husband, the false charge against wife, can this statement, my question is, can this statement has any chance of retraction? Retraction here means, can the husband take back his words? Can the husband take back his words, whatever he said, whatever the statement which he has passed relating to false charge to the wife in relation to adultery? Can he take back that statement? Answer in the comments. Let's see how many of you can answer. Okay, Kanika, do explain. Yes, he can. You are answering. Till what moment? Till what moment he can do that? Chaliye, now I'm answering this question, students. I'm answering this. So the answer to this question is the general way. The answer is no. Okay, he cannot retract. But if you are saying yes, till suit, till the moment of suit, which means suppose on today, on 13th of January, he made this statement. Now on 13th of January, he made this statement. If suppose wife has planned to file a suit on 15th January, so starting from 13th till 15th, if the husband convince the husband, okay, I'm really sorry, I was not meaning this, there was some misconceptions or whatsoever. If he convinced the wife, in that case, that can be retracted. But once the wife has filed the suit, then, and if the wife proved in the suit that it was a false charge of adultery, she has all the rights to take the talaq with the help of lien. I hope it's clear. Kanika, not before the end of trial, before the suit, before filing of the suit. Okay? Chaliye. Let's conclude this class. So this is the link of my profile, students. And this is my Telegram channel, and this is my code KHATRILIVE. This is the schedule of my classes as of now. I'm also running a series on MP test series. So let's crack PCS J with Unacademy, compete with thousands of aspirants and stand out from the crowd. You will get all the subjects here, students, all the major, minor subjects, everything is available on Unacademy. These are some special class features like interactive live classes, poll for learners. You can raise your hand and you can actually communicate with the educator. You will get the notifications, so you will never miss a class. You will get the lecture notes and you can access them anytime, anywhere. This is the pricing plan and the plus subscription. More the months, less the price, and you can always use the code KHATRILIVE for 10% off. Once you're a subscriber, you can attend all these classes from different educators. This is the YouTube and the Telegram channel of Unacademy. Kanika, I have 3 judgments on that point. So in case if you are not able to find that, I'll share all the name of 3 judgments on this. So don't worry. In my defense, I have 3 judgments. The 2 judgments from Allahabad High Court and 1 judgment from Bombay High Court. Okay, which concludes this point. whatever I told you. Okay? You're welcome, Kanika, and thank you for the kind words. On that note, students, do like, share, and subscribe. And yes, it's time to say peace.